Can you prepare a will on behalf of a loved one who is no longer competent? I'm Carrie Jacobson with Jacobson Family Law, and this is something that I recently saw in a Facebook group, and I thought it was appropriate to bring to people's attention because there was a lot of misunderstanding around this concept. So, first and foremost is no, you cannot create a will on behalf of someone else, even if you have power of attorney over them if they are no longer competent. A will must be created and signed by the person who is preparing the document, who the person whose wishes are being expressed. And they have to have something called testamentary capacity. So, testamentary capacity is something where your loved one must understand what the will is, what they have, what they own, and who the beneficiaries are going to be. Now, your loved one may be recently diagnosed with dementia or may be, have a mild cognitive decline. In those scenarios, it is possible that your loved one may still be able to sign a will, but it might be necessary to have a legal or a medical assessment to make sure that that will can't be challenged in the future by loved ones or third parties. Even if you have power of attorney for your loved one, this does not allow you to make changes to their will. So this is a large misconception. It doesn't give you the right to change or revise the will that they already have or to create a new one on their behalf. So when is it too late? It's going to be too late if they have already, lost capacity to understand what's going on. And unfortunately, in those scenarios, when they pass away, any assets they have are going to either go in accordance with the will that may already be in place, or if they don't have a will, then it's going to go in accordance with the laws in your state for what's called intestate succession. And so this is a statutory outline that says who the assets will go to depending on your loved one's situation, whether they have children, whether they're married, whether they have other family members, and it will depend on the state that you are in. So the best time to seek help is if your loved one is borderline, and is on the, cognitive decline, they should speak to an attorney right away to put their wishes in writing. So the big takeaway is that the best time to create a will is sooner rather than later. And if there's any question at all, see whether or not your loved one has mental capacity. You can reach out to their doctor and have them do an assessment. And if they are okay, have them do the will. If not, then unfortunately, it's going to be too late. If you have questions about how we can help you or your loved one create a will today, contact us at the link below.